Ladies and gentlemen, a good afternoon from Hong Kong. A big welcome to all of you to today's webinar, Effectively Resolving Disputes with Chinese Parties under the CISG. My name is Jintao O, Deputy Counsel at CITEC Hong Kong Arbitration Center, and I'll be the moderator today. Today's webinar is also one of the affiliate events of the 19th with these ISMUTs and has gained valuable support from our supporting organizations. They are NC12 Regional Center for Asia and the Pacific, the Department of Justice of the Hong Kong SAR, the Hague Convention on Private International Law, the Hong Kong Institute of Arbitrators, and the Chartered Institute of Arbitrators East Asia branch. And as of today, we have received over 300 registrations from more than 40 jurisdictions around the world. So due to the COVID-19 situation this year, today's event as well as the MOOCs are held online, and we are not able to see everyone in person in Hong Kong. However, we see the Hong Kong Arbitration Center truly welcome and truly hope that you could all travel to Hong Kong when the COVID situation is improved to participate in the next coming editions of the ISMUT, as well as to, more importantly, to experience arbitration culture in Hong Kong. And also, as I may know that many of you watching are participants of the ISMUT, if you are considering an engaging internship opportunity, you may want to check out online our global internship program, where we provide internship opportunities to passionate legal talents in related fields. In today's webinar, we will be looking at topics relevant to the CISG, as well as its forthcoming application in Hong Kong. We are very honored to have Ms. Teresa Cheng, Secretary for Justice of the Hong Kong SAR, Dr. Yang, partner of Stephenson Harwood, Professor Lim, Chong-Ming Lee Professor of Law at the Chinese University of Hong Kong, Dr. Dimsey, partner of CMS Hong Kong, Mr. Sun, partner of Zhongwen Law Firm, and Professor Zhao, Head of Department of Law at the University of Hong Kong, to join and share with us their valuable insights on relevant topics. And during the webinar, especially during the panel discussion session, if you have any questions to ask our wonderful speakers, please feel free to type your question in the Q&A box. All right, so without further ado, please join me to welcome Dr. Wenying Wang, Secretary General of CITEC Hong Kong Arbitration Center, to give welcome remarks. Dr. Wang, please.
Thank you, Jintao. Thank you. Madam Secretary for Justice, distinguished speakers, ladies and gentlemen, good afternoon. It gives me great pleasure on behalf of CITEC Hong Kong Arbitration Center to welcome all of you to today's webinar, Effectively Resolving Disputes with Chinese Parties under the CISG. Given the context of the ISMUT and the recent initiative of Hong Kong SAR to adopt the CISG, we find today a good fit to discuss CISG-related topics. CITEC, with over 65 years of history, is the most experienced arbitration institution in China. It is also well recognized as one of the 5 most popular arbitration institutions in the world. Last year, CITEC accepted over 4,000 cases. The total amount in dispute of cases reached over 123 billion RMB. CITEC Hong Kong, the CITEC Hong Kong Arbitration Center was established in 2012. The caseload of CITEC Hong Kong reached a historic high in 2021, which is an 88.9% yearly increase compared with 2020. The total amount in dispute of cases last year also witnessed a 74% yearly growth, with an average dispute amount of 29.6 million Hong Kong dollars. And 53% of the CITEC Hong Kong arbitration cases are conducted in English or English-Chinese bilingual. As the most successful substantive uniform commercial law treaty, the CISG has played a vital role in facilitating deal-making and providing uniform rules for resolving disputes arising out of international sales of goods contracts. In 1988, the CISG entered into force in China. In the same year, CITEC already accepted cases applying the CISG And since then, CITEC has concluded hundreds of cases where the CISG was the governing law. Last year, CITEC published a report covering 109 arbitration cases involving CISG applications to share its experience of CISG application and interpretation in CITEC practice. The report was recorded by the Onsuichu Law Library. CITEC is also the only arbitration institution in China that provides cases to the CISG database of the Peace University. Beyond the application of CISG in arbitration, CITEC has applied itself to promote the understanding and using of the CISG in China. Since 2000, CITEC has organized a pre-moot of the Vismoot in Beijing every year, the CITEC Cup. Each year, the champion and the runner-up of the CITEC Cup will receive a full sponsorship provided by CITEC to participate in the Vismoot in Vienna and the Vis Eastmoot in Hong Kong, respectively. Over the years, nearly 5,000 students have participated in the CITEC Cup, and among them, many have grown into the backbone of the commercial law and dispute resolution sectors. It is proud to say that CITEC is not only the witness of the global development of CISG, but also a pioneer of the CISG application in China. Hong Kong's adoption of the CISG will inevitably change the cross-border dispute resolution landscape in Hong Kong. Moreover, given that many of the Belt and Road countries are CISG member states, the implementation of the CISG will unquestionably strengthen Hong Kong's capacity for resolving Belt and Road trade disputes, bring unlimited opportunities to relevant sectors, and thus enhance Hong Kong's status as an international trade center and dispute resolution center. Although the CISG has not yet had effect in Hong Kong, CITEC Hong Kong Arbitration Center has already accepted a certain number of cases applying the CISG. Taking last year as an example, for all cases that we accepted, over 50% were international sales of goods disputes, and among them, over 20% were resolved under the CISG, involving parties mainly from the Chinese mainland and Europe. As with the abundant resources and advanced experience of CITEC in applying the CISG in resolving disputes over the years, I'm confident to say that CITEC Hong Kong Arbitration Center has a decided advantage in resolving CISG-related disputes. Ladies and gentlemen, to further assist the relevant stakeholders in welcoming the approach and implementation of the CISG in Hong Kong, CITEC Hong Kong Arbitration Center is going to launch a series of events and practical trainings in the near future. All of you are welcome to visit our social media for more information. Today's webinar marks the opening of our CISG-related events. Speakers of this webinar will give an overview of the impact that the CISG imposes in Hong Kong and discuss and exchange ideas on issues closely relevant to the topic. To conclude my remarks, I wish you a fruitful webinar today and wish all of you a nice day and good health. Thank you.
Now, it's honor to Teresa Chen, GBM, GBS, JP, SC, Secretary for Justice of the Hong Kong Administrative Region of the People's Republic of China, to deliver the keynote speech.
Ladies and gentlemen, good afternoon to you all. It gives me great pleasure to speak at this event. I would like to thank the CITEC Hong Kong Arbitration Center for organizing this webinar, which provides a valuable opportunity for the sharing of views and knowledge on this important topic of effectively resolving disputes with Chinese parties under the CISG. The National 14th Five-Year Plan supports the Hong Kong SAR to enhance its status as an international trade center as well as a center for international legal and dispute resolution services in the Asia-Pacific region. In line with the national plan, the Sale of Goods United Nations Convention Ordinance was enacted last September to enable the implementation of the CISG in the Hong Kong SAR. This marks an important development of our law on international sale of goods. Having celebrated its 40th anniversary in 2020, the CISG has been described as the most successful substantive uniform commercial law treaty. It embodies the collaborative efforts of many jurisdictions with different legal traditions and establishes a truly uniform legal regime for international sale of goods. Starting with 11 rectifying states, including China, back in 1988, the CISG has achieved wide adoption currently by 94 contracting states, covering most of the leading world merchandise traders, as well as more than half of Hong Kong's top 20 trading partners. The Hong Kong SAR will be able to take full benefit of the CISG for sales transactions between businesses of Hong Kong and other CISG jurisdictions upon completion of the relevant process under Article 153 of the Basic Law and formal notification by the Central People's Government to the Secretary-General of the United Nations as depository for the CISG. We are hopeful that the CISG will be applied to the Hong Kong SAR in full without China's Article 95 reservation later this year. This arrangement is made possible under the one country, two systems principle. Being an international treaty governing international sale of goods, the CISG does not apply to transactions within China as a matter of treaty law. In the government's public consultation in 2020, there was general support to apply the CISG rules to transactions between businesses in the mainland and businesses in the Hong Kong SAR by way of a bilateral arrangement between the two jurisdictions. To follow up, the Hong Kong SAR government is working on reaching such arrangement through discussions with the Central People's Government. This approach has been successfully adopted since 1999 in the context of enforcing arbitral awards under the New York Convention, which I shall talk about later on. According to the World Trade Organization, Asia outperformed other regions of the world in merchandise trade growth over the last 2 years. This entails growth in international commercial transactions and inevitably related disputes in Asia. As a deal-making and dispute resolution hub, the Hong Kong SAR, with the benefits of CISG, would certainly be in an even better position to leverage the global trend. Applying the CISG to the Hong Kong SAR could facilitate deal-making and reduce transaction costs, as it allows for a uniform sales law that is familiar to both local and overseas traders to govern the bulk of Hong Kong businesses' international sales transactions. The CISG would apply directly where a sale of goods contract is between parties located in different contracting states. This would avoid recourse to private international law rules to determine the law applicable to the contract, thereby introducing certainty and predictability in commercial transactions. Indeed, amid the robust development of cross-border trade, arbitration has emerged as one of the popular alternative dispute resolution mechanisms and is well known for its respect for party autonomy, neutrality, flexibility, and international enforcement. Over 4 decades since the adoption of the CISG has frequently been applied in international arbitration as the substantive law to resolve international trade disputes. Although the CISG is an international law treaty which mandates the adherence of contracting states and their courts, it is generally accepted that arbitral tribunals have a duty to apply the CISG as a choice of law made by the parties. Failure to apply the law chosen by the parties may incur a risk of the enforcement of the award being refused under the New York Convention on the basis of excess of authority or procedural irregularity. The CISG is no stranger to the arbitration community in Hong Kong. In recent years, we have seen international CISG-related arbitrations administered by local arbitral institutions. With the full implementation of CISG in Hong Kong later this year, I believe it will further consolidate Hong Kong's position as an international legal and dispute resolution center in the Asia-Pacific region and beyond. As a long-established free port, Hong Kong has been a major player in the world trade market with close economic ties with the mainland and the rest of the world. According to the statistics published by the WTO, in 2020, Hong Kong ranked 6th and 8th in world trade respectively in both exports and imports of merchandise. The global competitiveness is premised upon a variety of intrinsic strengths Hong Kong enjoys under one country, two systems. The Basic Law maintains the capitalist economic and trade systems and safeguards the free movement of goods. Hong Kong is also a separate customs territory from the mainland, adopting zero-tariff policy. The conducive trading environment lays solid foundation to the introduction of the CISG in Hong Kong, as well as the wider use of Hong Kong's legal and dispute resolution services to resolve CISG-related disputes. Hong Kong's leading position in arbitration is well supported by the international arbitration surveys conducted by Queen Mary University of London, in which Hong Kong was ranked the 3rd most preferred seat for arbitration worldwide in 2021, and indeed has continuously been the top 5 globally since 2015. As a world-renowned seat of arbitration, Hong Kong has much to offer. We have a well-established legal system underpinned by the rule of law and the independence of the judiciary. Hong Kong is also the only common law jurisdiction that practices bilingual law in English and Chinese, and the courts and tribunals can operate in both languages. As CISG disputes involve parties from different states, the bilingual setup would greatly enhance access to justice to both English and Chinese-speaking parties. The Arbitration Ordinance is an up-to-date legislation on arbitration law based on the latest version of the UNCITRAL Model Law on International Commercial Arbitration adopted in 2006. It is reviewed regularly and updated to stay abreast of the latest international developments. Statutory amendments were made in 2017 to clarify that disputes over intellectual property rights are arbitrable and third-party funding for arbitration is permissible in Hong Kong. In response to the recommendations of the Law Reform Commission on the introduction of outcome fee-related structures for arbitration in Hong Kong, we have recently taken steps to introduce legislative amendments to meet the expectations of users and industry players for flexible fee arrangements. Under the New York Convention, arbitral awards made in Hong Kong can be enforced in almost all contracting states to the CISG. The reciprocal enforcement of awards between Hong Kong and the mainland is given effect by an arrangement signed by the two jurisdictions in 1999, which was then refined by the supplemental arrangement in 2021. With the implementation of the groundbreaking interim measures arrangement signed with the mainland in April of 2019, parties to arbitral proceedings seated in Hong Kong and administered by eligible arbitral institutions can apply directly to the mainland courts for interim measures. This is certainly a game changer and gives Hong Kong a comparative advantage as the seat of arbitration in resolving CISG disputes between international and mainland parties. The Department of Justice has supported a series of CISG legal training workshops to prepare legal practitioners for the implementation of the CISG in Hong Kong. I am pleased to see this informative program being put together by our good friends from CITEC Hong Kong. I believe that training programs will help promote a more in-depth understanding of the CISG and its operation in arbitrations. Ladies and gentlemen, the Belt and Road Initiative has strengthened connectivity and opened up new trade opportunities between China and the rest of the world. Currently, over 140 countries are participating in the BRI, and nearly half of them are members of the CISG. It is envisaged that there will be more sales of goods, equipment and construction materials that fall within the ambit of the CISG, as well as related disputes, unfortunately, between enterprises in China and other BRI countries. The CISG is a successful commercial law treaty, providing a set of uniform rules to govern contracts for the international sale of goods and remove legal barriers in cross-border trade. Under one country, two systems, the full implementation of the CISG would enable Hong Kong SAR to capitalize on and further enhance its legal and dispute resolution services, as well as to harness the opportunities brought forth by the National 14th Five-Year Plan. On this note, I wish you all a fruitful webinar. Thank you.
Thank you so much, Madam Secretary. Now, before we move forward to our next session, the panel discussion, please allow me to introduce our moderator for the panel discussion, Dr. Fan Yang. Dr. Yang is a partner of Stevenson Harwood LLP London and advises on the laws of England and Wales, having been one of the first mainland Chinese called to the bar of the England and Wales. She specializes in international arbitration and cross-border dispute resolution. In addition to representing clients as counsel in international arbitration and cross-border mediation, she has also acted as mediator and has been appointed as arbitrator under the rules of the ICC, HKIC, AIAC, and SCIA. Dr. Yang, over to you.
Thank you, Jing Tao. Good afternoon, good morning, and good evening. Please allow me to thank the organizers for so very kindly having me moderate this panel discussion. I would like to congratulate Dr. Wenying Wang and all co-organizers for organizing this timely webinar in celebration of the adoption of the CISG in Hong Kong. The adoption of the CISG in Hong Kong is yet another successful contribution made by the UNCITRAL and the CISG community at large to the continuing development and furtherance of our commitment to global harmonization of international commercial law and peaceful dispute resolution. You will not be surprised to hear that the CISG is in fact one of my favorite little things, not only because it's the subject of my PhD thesis, which was published back in 2011, I know, can't believe, more than 10 years ago, but also because it is through the CISG that I have met so many remarkable CISG scholars and experts, mentors and friends in our CISG global community, including, of course, all of you, our mooters, coaches, moot arbitrators and judges. Professor Michael Bridge, in his most kind foreword of my book on contracts for international sale of goods in China, published in 2011, again, more than 10 years ago, commented that China was one of the first countries to adopt the CISG, and through a constant stream of CTAC arbitrations has made major contributions to the ever burgeoning case law on the CISG. At the time of adoption, China entered an Article 95 declaration against Article 11B, so that it will not apply the CISG pursuant to rules of private international law. In my book, I explain why China should reconsider its Article 95 reservation. I dealt with it also at length in my book that was published 10 years ago, need clarification on the status of CISG in Hong Kong, Macau, and Taiwan. Now, 10 years later, finally, I have this chance again to discuss one of my favorite topics. So today is a very happy day for me, a very happy day for our CISG community. I'm going to start with our first panelist, Professor Lim, who will present his arguments and thoughts on the adoption of the CISG in Hong Kong, focusing on issues concerning the applicability of the CISG under Articles 11A and 11B, and the PRC reservations and Hong Kong SAR's approach to the adoption of the CISG. Now, please allow me to just very briefly introduce Professor Lim. Professor Lim combines teaching at Chinese University of Hong Kong and practice as a barrister and arbitrator at Keating Chambers, London. And he's also qualified in Singapore. He's impaneled by, amongst others, CTAC, and was recently on AIAC Rules Revision Committee. His books include The Cambridge Companion to International Arbitration with a foreword by Laura Neuberger, that was published 2021, and Lin Ho and Paparinsky on International Investment Law and Arbitration with a foreword by the late Emile Gaillard, Cambridge University Press. He's also a visiting professor at King's College London, honorary senior fellow at the British Institute of International and Comparative Law, and was in 2021 elected to the Institute of International Law headquartered in Geneva. So Professor Lim, you have 12 minutes plus 3 minutes reserved for questions. Over to you.
Thanks very much, Fan, and thank you to CTAC for this kind invitation. Ladies and gentlemen, we've heard that for the longest time, Hong Kong's position has been that the CISG has had no application here, and we are now looking at the imminent extension of its application to Hong Kong. We expect in the third quarter of this year, the Sale of Goods United Nations Convention Ordinance was passed last year, but that is yet to come into effect. Thus, we have had a situation where, let's say, the United States, Germany, Singapore, all have the same international sales law as China, but Hong Kong has had our Sale of Goods Ordinance. What I'd like to do, if I may, is to illustrate with two scenarios what the situation has been, and then I would like to discuss two proposals, which some people may think quite unusual, by the Hong Kong government. And please let me emphasize that at this point in time, these are just the Hong Kong government's proposals. We will have to see whether the proposals will be implemented later this year. So two scenarios and two Hong Kong proposals. So in my first scenario, imagine a French judge, France being a CISG contracting state, looking at the PRC as another contracting state and applying what public international lawyers think of as Article 29 of the Vienna Convention on the Law of Treaties assumes that because the PRC is a CISG contracting state, that therefore it must apply where a Hong Kong party and another party whose place of business is also in a CISG contracting state enter into an international sales contract. Now, Hong Kong's position has been that this is wrong, as we would only apply the sale of goods ordinance. Well, now, as I've said, we have this new piece of legislation that was passed last year, which, as I also mentioned, will soon come into effect. Some say, why change the position at all? Because that will simply confuse people, at least in the immediate term. It has not been confusing elsewhere. So, for example, when Singapore adopted the CISG, some people said, well, if you're a Malaysian party and Malaysia is not a CISG contracting state, and you choose Singapore law, what you really expect is Singapore Sale of Goods Act Cap 393, which is based on the English Act of 1979. This brings me to my second scenario. So in the first scenario, it would be wrong from our point of view, for a judge in a CISG contracting state to treat an international sales contract involving a Hong Kong party and another party whose place of business is in another CISG contracting state as a transaction which attracts the application of the CISG. Now, in my second scenario, imagine two parties. One is a European party and the other is a Chinese party, but that Chinese party's place of business is in Hong Kong. So party A is European and party B is Chinese. Party B, the Chinese party, says, well, I want Chinese contract law to govern this contract. The European party, party A, doesn't want that, let us say, during the negotiations. But the European party thinks to itself, well, hold on, both parties have their places of business in CISG states. The Chinese party, whose place of business is actually in Hong Kong, has its place of business in a CISG contracting state, and so does the European party. Now, as I've mentioned, the problem is that this has not been the view in Hong Kong. And that, in fact, is our first scenario, which we say is now resolved. The problem is solved since Hong Kong will now accept the CISG. But here is where it gets a little bit more intricate. Say the European party, party A, then thinks, well, never mind. If we were to give in and we agree with the Chinese party that Chinese contract law, PRC contract law, will govern this contract, that nonetheless chooses the CISG under Article 11B rather than 11A when the two parties are in CISG contracting states. This would be wrong from the PRC's viewpoint, at least, because the PRC has entered an Article 95 declaration. Now, there is some detail here, which I should mention at this juncture, which we will come back to at the end. The Advisory Council itself, in opinion number 15, says that the better view is that all Article 95 declarations are in fact misconceived. And they say this because Article 11B only says when private international law rules of the forum lead to the application of, to quote, the law of a contracting state, then the moment you select the law of a contracting state, that is the end of the matter, Article 95 declaration or not. But let us put that aside for, as I've said, the PRC's position and position of a number of other countries is that when an Article 95 declaration is made, then Article 11B does not apply, so that if the private international rules of the forum were to lead to the application of the law of a contracting state, then if an Article 95 declaration has been entered, then you would apply the law of that contracting state. From the PRC's viewpoint, that would be PRC contract law. Here is where the two Hong Kong proposals come into focus. First, Hong Kong proposes that between Hong Kong and the mainland, that Hong Kong proposes that between Hong Kong and mainland parties, say one party is a Hong Kong party and the other party is a mainland party, the CISG will also apply by default. They are not from two CISG contracting states, but nonetheless, the CISG will apply by default in the same way, in a similar way, when the CISG applies by default, where the two parties have their places of business in two CISG contracting states. That's the first proposal. So it goes beyond the CISG to apply the CISG by default to Hong Kong and mainland party transactions. The second proposal is even more intricate because Hong Kong's proposal to the PRC is that the Article 95 declaration, which the PRC has entered, should not apply where the parties choose Hong Kong law, meaning that Hong Kong's position is that where two parties choose Hong Kong law, then the CISG will apply, unlike the situation where they choose PRC contract law. So let me just talk about these two proposals for another 2 or 3 minutes before I wrap up. As to the Hong Kong mainland arrangement, the first proposal, let's call it the Hong Kong mainland arrangement, where if you have a party from Hong Kong and a party from the mainland, then the CISG will automatically apply. That is not Article 11A, as I've said, of the CISG, because they are not from two CISG contracting states. There is a chance that if the parties were to choose a foreign court, let's say, that there might be some degree of uncertainty. A foreign court, even a foreign court in a CISG contracting state, which is therefore obligated to apply the CISG under the CISG's Article 11A, will say, well, here they are not two parties from whose places of business are in two CISG contracting states. They are both from one CISG contracting state. What is the solution? Or what can one imagine the solution to be? I think the short answer is that parties should be alive to this aspect of it, rather than to assume that simply because there is this arrangement, everything will always be well. Well, hopefully most of the time they will, but in this scenario, there could be some uncertainty. And so one answer is to choose PRC law expressly if that is what the parties want, thereby displacing the CISG under Article 6. Or if the parties want Hong Kong law, then they should make that intention plain, and they should displace the CISG under Article 6. But the most curious thing is this, and here is my suggestion, if I may. If they do want the CISG, rather than relying solely on the Hong Kong mainland arrangement, my suggestion is that even if one is a Hong Kong party and the other is a mainland party, even if all implementing measures are taken to implement this proposal, assuming it is accepted, it would make sense to incorporate the CISG as rules that govern the contract, particularly if you're choosing a foreign court or if you're choosing arbitration. Now, as for the second proposal, what is referred to as the split regime, where the Article 95 declaration, which the PRC has entered, will not apply to Hong Kong. This is where we come back to the CISG Advisory Council's opinion number 15, because as far as the CISG Advisory Council is concerned, even if there is an Article 95 declaration, Article 11B would apply anyway, such that if you were to choose Hong Kong law, then the CISG should apply. What the Hong Kong government proposes is for the PRC to notify the United Nations Secretary General as treaty depository stating that the PRC's Article 95 declaration will not apply in the case of Hong Kong. But that is a proposal made on the basis of an excess of caution. Regardless of the two proposals, and now, if I may, I'd like to conclude, regardless of the two proposals, whether it's the proposed Hong Kong mainland arrangement or the proposed split regime, parties should nonetheless want to expressly incorporate the rules of the CISG. Displacing the CISG depends upon expressing an intent to do so very clearly. If Hong Kong law is what the parties want. Maybe I should just add that you don't want to select the sale of goods ordinance expressly, because the sale of goods ordinance only deals with the law of sale, and it doesn't deal with the formation of the contract, doesn't deal with what a valid offer is or an acceptance. It doesn't have rules on contractual interpretation, and doesn't deal with liability and tort and so on. If you want Hong Kong law, if you want the sale of goods ordinance, you must express that intent clearly in the contract. I should stop there and relinquish the floor to Dr. Dimsey, because I think she will be dealing with some of these issues. Thanks very much, Fan.
Thank you, Professor Lim. We do still have a bit of time, so if okay with you, Professor Lim, we're going to just maybe have one question. And I think that it's very interesting that you mentioned this CISG Advisory Council's legal opinion. And we know that for the Article 11B, Article 95 reservation, there are at least 3 variations. It depends on the wording of these reservations were made. And US, China, and Singapore were grouped in one, as regarded as one variation. And then there are 2 other. One is the German variation, and the other one is the Dutch variation. And even within the first group, and I think the PRC's reservation is slightly worded, differently from the Singaporean declaration. So the PRC says, we do not consider, right? So the PRC does not consider itself to be bound by Article 11B. And Singapore says, well, we will apply the convention only where place of business of both parties are in different states. So the differences are, the reservation is to do with the reserving state. It doesn't necessarily have any impact or, authority over foreign courts and deciding on the application of the CISG pursuant to Article 11B. So going back to Hong Kong, are we going to have both the CISG ordinance, the Hong Kong Sale of Goods United Nations Convention ordinance, and the Hong Kong Sale of Goods Ordinance Cap 26, which is based on the English Sale of Goods Act 1979? So are we having the best of both worlds?
I think you put it very nicely, Fan. I think we would like to have the best of both worlds, and it's a question of getting there. In this instance, because of our position, which is that we would prefer to have not to have the PRC's declaration apply where the parties choose Hong Kong law, it works to our advantage that the CISG Advisory Council takes the view that regardless of your form of wording, because Article 11B simply says that the CISG applies where the rules of private international law, meaning the rules of private international law of the particular forum, lead to the law of a contracting state, they would put a full stop there. Law of a contracting state, full stop. And so any form of Article 95 declaration, I think it's quite extreme, this view, But that view is that any form of Article 95 declaration would not matter to the wording of Article 1B. And the advisory opinion goes on to cite a large number of authorities. Michael Bridge, whom you've mentioned, is one of the people they cite. They cite Franco Ferrari, they cite my colleague, Gary Bell at the National University of Singapore, and so on. And they take that to be the preferred view, however you read that. But it works to our advantage in Hong Kong, I think.
Yeah, and so practically, are we saying that for the PRC's Article 95 reservation, we have the option either to withdraw that reservation because it's not going to stop the use of the applicability of the CISG anyway, or if they have to maintain that Article 95 reservation, they could simply say that this reservation only applies to PRC because we are only reserving the PRC mainland Chinese courts does not consider itself bound by Article 11B, but it's entirely up to Hong Kong courts to consider otherwise, or any other contracting states to consider otherwise. That might be the options.
Yeah, it's just a proposal. And it's a proposal which I understand the Hong Kong government has made to the central government. And I don't think they put it in those exact terms which you mentioned. I think the way they'd like to put it is that this will not affect the PRC's own declaration, such that so far as we are concerned, if the parties were to choose PRC law, then the PRC's declaration would apply. That would be PRC contract law, as far as we are concerned as well. But all we're saying, suggesting, is that if the parties choose Hong Kong law without demonstrating an intention to displace the CISG, then as far as we're concerned, we'd like to have the CISG apply. And that, I believe, is also the proposal of the Hong Kong bar. And if I'm not mistaken, I think the Law Society took a slightly different view.
Thank you very much, Professor Lim. And you also mentioned Article 6, the parties can always explicitly agree to exclude the application of the CISG. Now, then comes our next question. How should parties make those choice when they should choose to apply Hong Kong law with the CISG, when they should choose to apply Hong Kong law, excluding the CISG, in other words, only the SOGO, the English style Sale of Goods Act applies. So with that, may I please now introduce our next speaker, Mario, Dr. Mario Dempsey, and she's going to help to take us through the Hong Kong SOGO, the Sale of Goods Ordinance, and highlight the key differences between these two regimes. Let me quickly introduce Dr. Mario Dempsey. Mario is an international commercial and investment arbitration specialist at CMS Hong Kong. She's the co-head of the Global CMS International Arbitration Group and has over 15 years experience acting as advisor and advocate in numerous international arbitrations. Mario has extensive experience in both common law and civil law disputes and has full professional fluency in German. Mario regularly sits as arbitrator and has experience as arbitrator under the HKIAC, ICC, KCAB, and the DIS rules, and in ad hoc disputes as well. She's listed on the arbitrator panels of several institutions. She's a past co-chair of the Hong Kong 45 Committee and a vice chair of the Women in Law Hong Kong. And she's consistently ranked in both the regional and global editions of the leading legal directories. And Dr. Mario, you have 12 minutes and plus 3 minutes reserved for questions, and the floor is yours. Over to you.
Thank you very much, Fan. I have to say, when you mentioned the 12 plus 3, for some reason, my mind was taken back to the moot and the reserved time for rebuttal.
That was deliberate. Thank you.
I'm very happy to be involved in this moot event, and thank you very much to CTAC and CTAC Hong Kong for inviting me to speak. I was a mootie myself, and now getting back to Fan's point before, now I feel old. This was 21 years ago. I competed in the 8th Vienna moot before there was even a Viz East moot. And it was actually competing in the moot that got me into arbitration as a career. And 21 years later, I'm very pleased to say that I'm still loving what I do, and really do think that the Viz moot, both the East and the Vienna versions, are invaluable experience for students who want to test the waters of international arbitration. And I'm so pleased that so many people have dialed in today. I will digress briefly with Professor Lim's very, very interesting discussion, because it reminded me of my very first case as arbitrator, which actually was under German law. And the discussion that we had, and it was an ICC case back then. So as my first case, the ICC Secretariat was incredibly helpful. And we had the dilemma where up until the point where I was appointed, the parties hadn't seemed to realise that the CISG was part of German law. So fortunately, they did realise eventually, so I was not placed in the position of whether or not I would alert them to that possibility. But up until that point, they had pleaded under the German Civil Code. So it was brought back memories when Professor Lim was discussing this point about how these reservations and these provisions in the CISG may seem quite dry and quite fixed in practice, but on paper, I mean, but in practice, they can actually take on a variety of different nuances that can make arbitrators and parties' lives quite complicated if they're not dealt with effectively. But anyway, I apologize for the digression. I will now turn to my topic, which Fan very kindly introduced me for. We are talking about resolving disputes under the CISG and the Sale of Goods Ordinance. I will start with a small disclaimer. I am much more proficient with the CISG than I am with the Sale of Goods Ordinance. Having said that, of course, looking at the Sale of Goods Ordinance, and as already indicated by Fan, there are many similarities with a number of what I'll call common law ordinances or acts that deal with sales of goods. As has already been pointed out as well, I should also mention that this comparison today is perhaps slightly construed for the fact that both the CISG and the Sale of Goods Ordinance deal with a very small part of the contractual relationship usually. I'll discuss what they deal with specifically in a moment, but it's very important to keep in mind that both of these instruments do not exist in a vacuum. And it's very important to ensure that when you are looking at them, there is always the background or the context of the applicable law, which does inevitably become relevant when you are actually dealing with a real life dispute. So with that, and I should also mention, thank you very much to CTAC Hong Kong and Jintao's team for helping me with my slides, because I'm not controlling them myself. And with that, I'll ask to go to the next slide, please. So today, in my 10 minutes left or thereabouts, I will go through very briefly, and I understand this is an educational exercise as well as an academic discussion. So I do look forward to questions at the end, but I will start with introducing the CISG, a brief introduction to SOGO, and then of course the salient features and key differences between the two instruments, which I think is perhaps most interesting in light of Hong Kong's recent developments, and following on from Professor Lim's explanations as to giving an informed discussion and therefore procuring informed consent or informed ideas about which is preferable for the particular dispute at hand. I will of course leave it to Professor Lim to explain or to reiterate it perhaps later in questions as to how that should be formulated in the contract, but the awareness of the differences is certainly very important for making any decision in that respect. Next slide, please. Okay, so the CISG, I'm sure I see that we have 185 participants today from many jurisdictions, different time zones. I'm assuming a lot of you are students and are participants in the moot, you're mooties. So I'm sure you need no introduction to the CISG, but I will give you one nonetheless. I like to see the CISG, and I should mention part of my career before turning to private practice was that I worked for Professor Schwenzer at the University of Basel. And as many of you will know, she is one of the editors of one of the leading commentaries on the CISG. And while I was preparing for my PhD back in 2004, 2005, one of my tasks was assisting with proofreading and the like of the English version of this commentary. So that was a continuation of my moot life at the university. And I also currently co-author the International Sales Law Casebook with Professor Schwenzer and Professor Funtulakis, who are both still based in Switzerland. So I've got a slightly perhaps more detailed impression of the CISG than I did have when I was a mootie. But the more I work with the instrument, the more you really do see the perfect combination of civil law and common law aspects that have been molded together in this wonderful document that really gives what I like to think is a true combined international instrument, which is made up of international best practice and taking the best from jurisdictions that have sales of law acts or have more jurisprudential approaches, and of course the civil law, civil code approaches that you get in the civil law jurisdictions. In light of the recent developments in Hong Kong, of course, I do think that this is a very, very welcome development. I think the clarifications that have been undertaken in the lead up to the ordinance, which has not yet come into effect, are very helpful. And I do think it will add an additional attraction for selecting Hong Kong law, when correctly worded, as the governing law, and thereby incorporating the CISG. I think this has a run-on effect for Hong Kong as a seat of arbitration, and it will definitely strengthen the position of Hong Kong as a place to, as a system that you can use for your international sales law disputes, and also hopefully as a follow-on, as a seat to resolve those disputes, ideally by arbitration. And I'm of course speaking from my private practice hat, and when I say that. So the uniform rules that the CISG sets out, as I've mentioned, they derive inspiration from both common and civil law. They range from the formation of contracts, which is a very important part, of course, as you see from the moot problems, which is reflected in real life. Many disputes arise from whether or not a contract has been validly concluded and what its content is, and the rights and obligations of the contracting parties, of course. One of the interesting areas of the CISG, which I think is probably more a civil law inspired system within a system, is the wide-reaching structured remedies that the buyer and seller both have available to them in the event of contractual non-performance, be that due to a breach or be that due to another impediment which prevents a party from performing its obligations as agreed. As I mentioned before, and this is largely repetitive, where the CISG is applicable, and I note from the consultation paper that was available online or is available online, this appears to be the approach that Hong Kong will take, where there are competing provisions between the CISG and the SOGO or another law for that matter. The CISG will prevail, but as I mentioned before, it's important to realise that the CISG itself also has limitations, and that in a real life dispute, it will inevitably, there will be gaps that will need to be filled by the domestic law. Next slide, please. Introduction to SOGO, as I mentioned, when I looked through this, and I have actually used it in my practice in Hong Kong, not to the greater extent as I have the CISG, but it is what I would call a traditional common law approach to the sale of goods. You have more detail in there on several aspects. You have different detail than you do in the CISG. And the focus and approach is understandably and obviously slightly different. You'll come across terms like conditions and warranties, whereas in the CISG, in articles like Article 35, there's a different approach taken, and there's a lot of discussion, for example, in the casebook about how those concepts line up in practice. One thing that I think has quite a few provisions dedicated to it in SOGO is questions of title. Now, as we all know, or as I as a common lawyer learnt in university many, many years ago, the questions of title form the basis of many disputes in practice and are often quite tricky to navigate. Now, I'll mention this again in a moment, but the CISG does not deal with property in the goods. It talks about how you get to the contract. It talks about how you can avoid the contract, what the remedies are if a party doesn't perform, but this detail into the passing of title and implied undertakings as to good title, those kinds of things are not regulated by the CISG. Turning back to SOGO though, it contains provisions about implied undertakings, not just to title, but also as to quality and fitness and those kind of terms, which are perhaps more easy for the CISG as well. And it also addresses the typical common law problems, as I'll call them, with respect to transferring title. What happens if there's defects in title? The famous purchaser in good faith for value without notice. How do you address their rights when there is a defect in title that they were unaware of when they undertook or when they assumed possession or title to the goods? So those kinds of questions. Next slide, please. So the key differences between the CISG and SOGO. Now, this is not, I should mention, this is not intended to be exhaustive. This was the points that I pulled out when looking at the two instruments in light of practical implications, which I'll turn to as a next step in this presentation. But I do think these differences will have an impact on how people structure their transactions, how contracting parties should ideally behave, depending on whether they are under the CISG or they're under the Sale of Goods Ordinance. So one of the most important ones, I think, which is a fundamental tenet, I think, of the CISG, is that Article 11 constitutes departure from the parole evidence rule under common law. So witnesses can be used to prove the existence of a contract, whereas, as many of you will know, the parole evidence rule generally does not allow the admission of oral statements to support any aspect in that respect. In a vein, I'll call it, Article 29 of the CISG could have the potential for misunderstandings, whereby it prescribes the modification of a contract by mere agreement. And again, the implication there is that this could also be orally. And I do think that this is very reflective of the international realities and the fact that the CISG is trying to appeal to those. But at the same time, if you're working from a common law system, you need to be aware of the fact that this is actually quite different from what the common law would generally prescribe. Articles 19 and 21 of the CISG deal with this very, what I like to think of, it's slightly structured, but it's also quite complicated, of getting to the conclusion of a contract under the CISG. And if I'm not mistaken, I think about 6 or 7 articles are devoted to this. And it all works perfectly when you look at it step by step. But there's a lot of hoops that you need to jump through to ensure that you don't fall foul of getting to a valid contract at the end of the day. So, of course, with Article 19, this talks about material and non-material changes when you are responding to an offer, and how this will affect the actual content of what is agreed between the parties. Of course, if it's non-material, essentially the contract will be the scope of what has been exchanged. So the offer and the non-material changes that were proposed to this offer. Whereas if it's material, it has a different impact altogether and will then essentially result in the offeree becoming the offeror, making a counter offer, which of course has different ramifications, and the steps sort of started to work again. 21 has a similar kind of inspiration, if you ask me. It's referring to the situation where if an offer has lapsed and the offeree accepts it nonetheless, the offeror is then under an obligation to object to that promptly. Otherwise, they may still be held to what would otherwise have been a lapsed offer. So these kinds of things can be quite important in practice. Very briefly on the concept of avoidance. This is, I think, a transnational concept, which is very, very difficult to explain in both civil and common law, because we all have slightly different terms that we use to convey a similar meaning. Now, of course, you've got Article 25 of the CISG, which talks about a fundamental breach of contract entitling avoidance. So there you've got the notion of a remedy of last resort. So as was to be expected in international sales contract, you don't want to avoid the contract, get rid of the contract, unless there really is no other way out of it. So they've set the bar very high in Article 25, and it really has to be fundamental. The other aspects where you can avoid come through in the remedies available. And if a seller delivers defective goods, that is not the end of the matter. Then there is generally the obligation to allow the seller a reasonable time to repair or deliver substitute goods, which, if that then fails, may entitle the buyer to declare the contract avoided. So again, you see this structured approach to getting out of a contract, whereby you can't just terminate for a very minor or trivial thing. It has to really have been attempted to resolve it. And only when those attempts fail is the contract then unavoidably avoided, I guess you could say. Next slide, please. Okay, moving on to once the goods have been exchanged and possession has taken place, Articles 38 and 39 do have strict requirements for notification of defects. This is a slightly different approach to what we have under common law, whereby you can inspect if you are asked to, more generally speaking, but here there is an active obligation. If you want to rely on defects, you need to inspect and notify of those defects within a reasonable period of time. Very quickly, Article 79 of the CISG talks about exemptions of liabilities due to impediments beyond a party's control. It's similar, but not the same as the common law concept of frustration, and also has elements of sort of force majeure and ideas, concepts like that. So it's important to be aware of the differences so that you don't get caught in your domestic concept and slightly miss the target in terms of what Article 79 is trying to do. And lastly, as I've already said, the CISG is not concerned with the effect the contract may have on property and the goods sold. Next slide, please. So implications for practice. Horses for courses is a term that I love to use, but it's basically just saying, look at what you're actually doing and make sure that the solution you're proposing is appropriate. So of course, as Professor Lim has elaborated, it is possible to opt out of the CISG or opt into the SOGO if the common law approach is preferred. If the CISG applies, watch out for the impact of your oral representations, and you may wish to consider including entire agreement clauses or no oral modification clauses to avoid otherwise what would apply if the CISG was the fallback position in the absence of an explicit clause to the contrary. Clear communications in pre-contractual negotiations. I think that's a general rule for regardless of which system you're operating under. Object to additional terms promptly and clearly. Reject acceptance of lapsed offers promptly and clearly. And you shouldn't end up with any unexpected results when it comes to the unfortunate situation of a dispute. And as Professor Lim has spoken about at length, I will not elaborate any further, but the CISG does not apply to transactions between Hong Kong and mainland China. So there is a different arrangement that is envisaged. I think that's it from me.
Thank you. Thank you
Sorry
very much.
for going slightly over time.
Exactly. Well, obviously, I'm a very generous moderator, and especially on a happy day like this. Let's quickly move on. We will come back to Dr. Dimsey later if we still have time for questions. Let's quickly move on to our next speaker, Mr. Sun Wei. Let me quickly introduce Mr. Sun. Mr. Sun is a partner at Zhonglun Law Firm, qualified to practice in PRC and the New York State. He graduated from New York University, LLM, Souls of University of London, LLM, and China University of Political Science and Law, LLB. He's a panel arbitrator of Singapore International Arbitration Center, Hong Kong International Arbitration Center, AIAC, and also Arbitration Foundation of Southern Africa and Tashkent International Arbitration Center, and among many others, and including some domestic, other arbitration commissions in the mainland of China, for example, Shenzhen and Ningbo and Shijiazhuang, etc. And Mr. Sun, you have 12 minutes and plus 3 minutes reserved for questions. Over to you. Thank you.
Thank you very much. Okay. Dr. Fan, can you see the slide? Can you see the slide? Can you see the slide?
Sorry. Yes, we can see it. Yes.
Okay, thank you.
Okay.
Yeah. Today I'm going to do a case study involving a CISG, which is the applicable law, and the subsequent setting aside of the award, and probably we can have some takeaway there. So in this case, there is a Chinese seller and also a Spanish buyer, and the Chinese seller initiates. Actually, Chinese seller sells solar panel, and then the Spanish company use the solar panel to build a factory and then sell the factory. That's their model of a business. And then the Chinese seller initiate arbitration against the buyer for a late payment. And then the buyer counterclaim, saying that the solar panel was defective because it lack of the TUV certification. So this constitute a fundamental breach, and then they are entitled to avoid the contract and to get the refund. So let's look at the relief sought by the buyer. the buyer said that if the arbitral tribunal found that there is a fundamental breach, then the contract should be avoided and money should be the contract should be avoided, and they can consider the refund of the refund of the purchase price should be ordered. And if the arbitral tribunal finds that the seller does not constitute a fundamental breach, then there should be a price reduction. So two approaches of reliefs. So if you look at the CISG, and if the seller breach, did the seller? So first question is, did the seller breach the supply contract? And if the answer is yes, and then there's another contract, was the buyer entitled to rely on seller's breach? And if the answer is also yes, then the seller breached the fundamental. If it constitutes fundamental, did the buyer lose the right to avoid the supply contract? If the answer is no, then whether the buyer gave a notice of avoidance. And if the avoidance has been given, then the supplement contract should be avoided. The supply contract should be avoided. Then there's another question. The buyer must account for the benefit since it cannot make substantial restitution of the solar panel. So the account for benefit it's a subsequent effect of the supply contract avoidance. And then if the buyer does not account for the benefit, the seller can withdraw the money which they need to refund. If the buyer account for the benefit, then the seller should refund the purchase price. So that's the arrangement. If there's no, if the breach does not constitute a fundamental breach, or if the seller fails to give a notice of avoiding of the contract, then the buyer can seek price reduction. So that's the arrangement of the reliefs according to the CISG. And then let's look at the logic of the arbitral award. The arbitral award. So the tribunal found that the seller did breach the contract, and then the buyer was entitled to rely on seller's breach, and the seller's breach was fundamental, and the buyer did send the notice to the seller. So if you follow the logic, if you follow the stipulation of CISG, at this stage, the contract should be avoided, the contract should be avoided. But the arbitral award, the arbitral tribunal jumped to conclusion, said that the buyer refused to account for the benefit. So there's another story said that the buyer said, I will not disclose how much I've already made by selling the power station. So the buyer refused to account for the benefit, and therefore the arbitral tribunal said the contract cannot be avoided. So, but the buyer can claim for price reduction, and the price should be reduced to 0. So that is the arbitral tribunal's decision. Fundamental breach, but the contract supply contract are not avoided due to the buyer refused to account for benefit, but the price can be reduced to 0. So, but on the side, but at the side of at the seller's side, they need to refund. They need to refund the purchase price, which is $60 million US dollars. So that's the arbitral award. And then we're applying to set aside the arbitral award, and we say that the decision the decision on matters beyond the scope of submissions. So both parties argue that if there is a fundamental breach, the contract should be avoided. And if it's not fundamental breach, then the arbitral tribunal can consider the price reduction. But nobody consider that if there's a fundamental breach and then jump to the remedy of price reduction. So we did not argue that. The opposing party did not argue that. And then Singapore High Court said that in the submission and during the hearing, neither party argued the buyer account for the benefit is a precondition for avoiding the supply contract. Yet the tribunal made a decision on this issue on his own without giving seller any opportunity to plead his case. So this decision has a decisive impact on the award. It directly led to a key part of the award. So this award was not made, this award not only made beyond the scope of submission, but also breach of natural justice. So the contract was, the arbitral award was set aside by the court. So the takeaway from this case is that for arbitrators, when CISG applied to the contract, the arbitrator need to carefully examine the relationship between the different remedies provided under the rules, and always bear in mind that the focus should be on the argument submitted by the parties, and decisions shall be made within the scope of submission. But the four lawyers gave full consideration to the possible remedies applicable under the CISG and make submissions accordingly. So if it's a CTAC arbitration, I think there is a very useful arrangement, which is a scrutiny, according to the CTAC arbitration rules 2015, Article 50. So CTAC will conduct scrutiny, which will try their best to avoid these kind of things. So that's the things that I want to share with you all. Thank you very much, Fan.
Thank you, Mr. Sun. Thank you, Wei. This is a very interesting case. I think that we have 2 minutes left for our time. We have up to 5:50, as I understand. So perhaps we could just very quickly explore this case. I'm just looking up on the ancestral model law, the one that Mr. Sun referred to in his PPTs, Article 34(2)(a)(3). It deals with the submission to arbitration. So obviously, this is very interesting to, a case to see that the Singaporean court has taken a very narrow an approach to interpret the submission to arbitration very narrowly, to mean that the submission to arbitration, not in the usual way that we consider, that means the agreement, right? The scope of the arbitration agreement, but merely referring to the submission to the arbitration proceedings, the submissions made by the parties during the arbitration process. I must say this is extraordinary. But going back to the CISG point, and I think that Mr. Sun has really highlighted the differences in the way that remedies are dealt with under the CISG and perhaps, let's say, the common law approach, because remedies obviously are very different under the common law and civil law approaches. So, are we comparing apples and oranges here, Mr. Sun? In your experience, I suppose the question is, do you see that the mainland Chinese parties will feel more comfortable, or their comfort level will be increased now that if they know CISG is part of Hong Kong law? Would that make them more comfortable to choose a Hong Kong law as the governing law, Mr. Sun?
Absolutely, so yes, absolutely.
And if I may also invite, thank you, Mr. Sun. If I may also invite Dr. Mario Dempsey back to, join us again. Again, I can see the time is 5:50. Dr. Dempsey, are you there? Right.
I'm still here.
Right. So very quickly, a question: are you happy that you can now go to talk to your common law clients to say, if you want, you can still have the, SOGO, but you can also say to your German clients, if they are more comfortable with CISG, now that you can choose Hong Kong law because CISG is now part of, or will be part of Hong Kong law. Is that how you see that that would go, or you are going to take a more cautious position there? Thank you.
I think, I mean, one thing that came out of Professor Lim's discussion before mine was that different countries really do take very different approaches in their domestic interpretations of what the agreement has been. And I think always it's best to be as specific as possible in your choice of law clause. So if you want CISG to apply, you should write Hong Kong law, including the CISG. If you don't want the CISG to apply, then you should write Hong Kong law with respect to the sale of goods questions, the sale of goods ordinance cap, whatever it is, I can't remember the original sale of good ordinance cap number, but making it very clear that the CISG is not encompassed by that party intention. So I would have no problem advising my German clients to agree on Hong Kong law, but I would give them a couple of additional pointers as to make that as clear as possible.
Thank you. Thank you so much. With that, let me close this panel. Professor Lim, sorry, we don't have time for more questions. I'm now going to hand this over back to Mr. O, please. Jingtao. Thank you.
Thank you. Thank you very much. Thank you for our wonderful speakers in the panel discussion, Dr. Yang, Professor Lim, Dr. Jameson, and Mrs. Sun, for the very insightful sharing. I personally learned a lot, and I think that our audience will feel the same. And now it's our great honor to have Professor Yun Zhao to deliver the closing remarks. Professor Zhao is Henry Chen Professor in International Law and Head of Department of Law at the University of Hong Kong. He is currently representative of Regional Office for Asia and the Pacific of the Hague Convention on Private International Law, Standing Council Member of Chinese Society of International Law, and Council Member of Chinese Law Society, Chair Professor at Xiamen University. He is listed as arbitrator in several international arbitration commissions. He has published widely on various topics, including particularly dispute resolution and space law. Professor Zhao, the floor is yours.
Thank you, Jingtao. Madam Secretary for Justice Chen, Dr. Wang, distinguished speakers, ladies and gentlemen. Good morning, good afternoon, good evening. So it is my great pleasure to give closing remarks for this very important event. I would like to thank the organizer, the CITEC Hong Kong Arbitration Center, for inviting me to this event. The event takes place at this very critical time. As Professor Lin has mentioned, the Sales of Goods United Nations Convention Ordinance was enacted last September with the aim to apply the CISG in a Hong Kong SAR. This ordinance will come into operation in around the third quarter this year. To prepare for the implementation, Hong Kong businesses and their legal advisors need to be familiar with the CISG and their implications for their international sale of goods contracts. Thus, this webinar very timely looks into not only the theoretical aspect, but also practical aspects of dispute resolution under the new arrangement. As Madam Secretary for Justice mentioned in her keynote speech, the CISG provides substantive law rules governing international sales of goods contracts and largely avoids the conflict of law issues, which happens frequently in our commercial world. The application of the CISG will introduce certainty and predictability in commercial transactions and decrease transaction costs. In the meantime, we may also note the efforts of Ancitral, UNIDOA, and the HCCH in the issuance of the tripartite legal guide to uniform instruments in the area of international commercial contracts, with a focus on sales last year. The central theme of today's webinar is to look at dispute resolution with Chinese parties. The panel members, under the capable moderation of Ms. Yang today, are all experts in the field. They share with us their practical tips concerning dealings in the international sales of goods under the CISG. It is to be noted that mainland China has already been a member to the CISG in 1988. Being an international convention governing international sales of goods, the CISG does not apply to transactions with mainland China, between the mainland China and Hong Kong. As Madam Secretary for Justice mentioned, a mainland Hong Kong SAR arrangement with similar rules may be reached for this purpose. Ms. Dempsey rightly pointed out, the CISG provides a common language for businesses to transact globally and resolve related disputes. Applying the CISG will enhance Hong Kong's legal infrastructure for international sales of goods and bolster its role as international hub for trade and dispute resolution. Thus, the legal and business sectors will be able to put it to good use and benefit from the regime. In the future, the selection of Hong Kong law as governing law will no doubt facilitate the resolution of disputes in Hong Kong. In the meantime, we should also be mindful of the differences between the CISG and the SOGO in Hong Kong. On the other hand, the CISG is often welcomed by parties and arbitrators because of its neutrality, that the law does not favor parties from a particular country or region. This may help enhance ability of the Hong Kong arbitration community to handle CISG-related disputes, thereby enhancing the confidence of the parties in Hong Kong law and arbitration system. This also reflects the importance of this event. The application of the CISG in Hong Kong will help to boost the confidence of merchants, which will not only promote Hong Kong's international trade transactions, but also encourage all parties to resolve disputes in Hong Kong. However, we should also be careful in the practical application of the CISG. Mr. Sun enlightened us on the importance of giving full consideration to relevant provisions in the CISG through a real arbitration case. Since the CISG is a standard law that parties around the world are more familiar with, it can save time and cost in handling such disputes. The outcome of our discussion today will also provide ideas for enhancing the capacity building of the Hong Kong legal community for handling disputes arising from the pandemic. Furthermore, this is especially effective given Hong Kong's role in the Belt and Road Initiative. Through our panel discussion today, I think we have made it clear that applying the CISG, a set of international rules designed to provide clarity for most international sales of goods transactions, Hong Kong can further improve its ability to resolve disputes arising from BRI-facilitated transactions. At the same time, it will also lay a solid foundation for becoming a member of RCEP in the future. This discussion has been fruitful and informative, and the webinar today will surely provide many new ideas for our future legal research and legal practice to ponder and explore. Finally, I acknowledge and appreciate the excellent presentations and speeches of our keynote speaker and the panel members. I'm very grateful for the commendable leadership of the organizer, CITEC Hong Kong Arbitration Center. With that, all that is left for me to say is congratulations on a wonderful webinar, and that, like many of the speakers and the guests today, look forward to joining the event again to have further discussions of the CISG in future. Thank you very much. So with this, I pass the floor back to Jingtao.
Thank you so much, Professor. Yes, as I just see that some of you are asking whether whether we will upload our video to the website. And with that, I think please make sure that you subscribe to our YouTube channel and Bilibili channel. You won't miss any of our updates. Okay, so as with limited time, may I invite all our speakers today to have a group photo. All right, so on 3, 2, 1, cheers. Thank you so much. At the very end, I would also like to extend our sincere gratitude again to all our wonderful speakers today and to all of you who are watching online. And I hope you find today's webinar useful, and I look forward to seeing all of you in person in the future in Hong Kong. Have a nice day. See you next time.